Yesterday in Abuja, the nation's capital, the appeal court delivered a ruling that restores Senator Adeleke as the duly elected governor of Osun State in southwest Nigeria. What materially changed on that part between the state governorship elections tribunal and the appeal court seems to be the dominant question among lawyers and students of the law this morning. And to try to make a sense of it all, we now turn to Liborous Oshoma, a constitutional lawyer and public affairs analyst. Good morning, Liborous. Good to have you with us.
Thank you. Same here.
Absolutely, thank you. I know that in Oshogbo, the dance will have continued, but of course, what a lot of people will be interested in will be the letters of the law and how the appeal court, was able to swing it back, to Governor Adeleke, basically nullifying, the position of the tribunal and saying that this indeed is the governor. What are the issues to start with? And if you like, you can take it with, are we having the deja vu of what we had 4 years ago when when Adeleke, as the challenger then, won at the tribunal but lost at the appeal court and Supreme Court. Is that what we're about to experience now?
No, I think it's a bit different here. Let me start from the tribunal. What's in issue here? It's even the general questions that people are asking at the Presidential Election Tribunal. The beavers.
Yes.
The place of beavers, the place of overvoting, and how to prove irregularities in any election.
Yes.
Mind you, in that election you referred to, Adeleke Oyetola was declared the winner of the election. And
That's
so
right.
it was the moment election results are declared, the presumption is that they are regular. It is the onus of proving that they are irregular is now on the man who is questioning the regularity of that process.
Yeah.
And also, the materials for proving the irregularities are domiciled with the man who had declared that the elections are regular. So that was what led to the issue at the tribunal in the Osun case. Mind you, APC applied for a certified true copy of the beavers report stored at the back end. And from that report, they allege overvoting. PDP also supplied, PDP and INECs supplied a further report,
Yes.
and that those two reports, there were discrepancies. And so the tribunal now called for a physical examination of all the beavers machines. And on the physical examination, it tallied with the result declared. So, but the tribunal went ahead to say that there was, because there were inconsistencies in the report on the back end, and that indeed there was overvoting. Because if you look at section, permit me to read section 47.2.
Okay.
To vote, the presiding officer shall use a smart card reader or any technology device that may be prescribed by the commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intended voter in the manner prescribed by the commission. And then section 51.2 now says, where the number of vote cast at the election in any polling unit exceeds the number of accredited voters in that polling unit, the presiding officer shall cancel the result of the election in that polling unit.
Yeah.
So the question was overvoting.
Yes.
And so the tribunal relied on the fact that since the physical examination of the beavers in court was an afterthought, can be manipulated. That was the opinion of the presiding judge of the tribunal. But the Court of Appeal, in its wisdom, I would also permit me to read, from the judgment of the Court of Appeal. It says that a case of overvoting can be established, for any case of overvoting, before a case of overvoting can be established, the person making the allegations must present the voters' register, the beavers, which contain the information of accredited voters, vote cast in each polling unit result has entered into in the Form EC88 amongst other things. The tribunal went further to say that APC hinging the allegation of overvoting on only information obtained from a secondary source, that's INEC backend server, was faulty. And then further, that on overvoting, that for the case of overvoting, you cannot rely on the weakness of your opponent's case, that they supplied, the information supplied where there were discrepancies in the report supplied by PDP and INEC, that you have to rely on the strength of your case, and a failure to call witnesses from those polling units where the voting took place was fatal to their case, that you must first and foremost prove substantially that there was overvoting before you now call on the defense, the respondent, to disprove whatever you have proven. So all of these issues also are replicated at the tribunal at the center. These are the basic questions that people are asking. So what basically played out in Osun is the fact that the beavers, the tribunal had, not completely still jettisoning the issue of voters register, that you must marry all of them together, the question of voters register, the beavers that was used, and then also the result sheets for those elections, and that you must also call witnesses from those polling units. So, and that's why I said there is a difference, because what the tribunal is basically looking at now is the regularity of the result that had been declared, and the law sees it as regular. So you need to go the extra mile to prove the irregularity. Don't just come with documents and say, I obtained these documents from the back-end server, and so since there are discrepancies, it means the election was irregular.
I mean, based off of this, we're looking at, looking at this tribunal result, and even the APC Council yesterday did say that they were in fact going to go to the Supreme Court. Can you forecast, I mean, based off of what you said, what their next move should be if they were indeed going to take this back to the Supreme Court?
Nigeria is a very funny country, but let me quickly say this before I forecast. If you look at the team of lawyers representing both parties at the tribunal, the team of lawyers for the APC is almost the same. They still have some of them at the APC presidential tribunal team. And then for the PDP, you still also have some of them in the Labour and PDP team. So the sides are going to be flipped. So the argument at the tribunal for the APC lawyers would be, it would be a reverse of their argument at the tribunal, at the presidential election tribunal. So what they are going to be arguing is that this election substantially complied with the provisions of the law. Meanwhile, in Osun, they are saying, no, the election did not comply with the provisions of the law. And then the other team are going to be arguing that the elections did not comply. But in Osun, they are saying that the election, had complied with the provisions of the law. So basically, and here, because politicians are very funny, they would want to exhaust all the privileges. So even at this stage, when you expect that now, with the off-cycle election, there should be end to litigation, but they want to see to the end. They want to exhaust their right to appeal, and so certainly they will go to the Supreme Court, give Supreme Court opportunity. But we have also seen cases where even the Court of Appeal, will nullify an election, and it gets to the Supreme Court, and the Supreme Court says no, it was on all fours. Because even at the Court of Appeal yesterday, the issue of the qualification of Adeleke, also came up. And the Court of Appeal said, well, that issue has been dealt with by Court of Coordinate Jurisdiction. So there's no need, also making a pronouncement on it. But at the Supreme Court will not be relying on the judgment of the Court of Appeal, because that might just be persuasive. So all of these issues are also going to be raised at the Supreme Court, the issue of qualification. And how well the Supreme Court will deal with it also, it's a different ballgame. But from the judgment that I have read so far, and going by the other judgment and the position, not too radical position of our Supreme Court, I do not see the Supreme Court departing from the judgment of the Court of Appeal delivered yesterday.
Okay, how much of the mood of the state, the mood of the community, how much of it can possibly influence judgment? What many people, laymen, of course, are saying is that we would like to see how a court of appeal, or ultimately the Supreme Court, will say to the people of Osun that a man who won a governorship election, but then several months after the general elections held, he won emphatically, for his party at the presidential level, and then at the State House, of Assembly level, practically cleared, all the elections. And as the governor, as the sitting governor, is like the leader of the party. Does that count when when justices are looking at the merit of the case, or they just stay by the technicalities and what is brought before them?
Yeah, you see, that's why I said not too radical Supreme Court. In other societies, in other climes, you would expect that the mood also, in some cases, these judges are not outside of the country, not outside of the state. They also will gauge the mood generally. But here, the judges don't bother looking at the mood or previous or past elections in the state. That is not their business. In fact, lawyers will go berserk the moment they even make reference to it, that these are not issues that were submitted for adjudication. So why should they even be bothered? If they were looking at the mood in the election in Imo, that brought Hope Uzodinma,
who came forth
in that election, the judges, if they were looking at moods, they would have looked at the mood of the people in Imo State. If they were looking at the mood, you remember the election between Oshoma and Osumbo, Professor Osarime Osumbo. The people, when Osumbo was sworn in, the people agreed that the elections were regular, but the people were happy that yes, they had, and because the man started well. So, but really, the courts don't look at moods. They look at the material evidence supplied before them vis-a-vis the provisions of the law. And so that's why in most cases, because Nigerians look at mood, lawyers will look at the mood, and then, analysts will look at the mood and say the people have settled in, they seem to be happy with the way the governor has started so far. Because, we have very short memory, forget these things. But it is good. It is also good that at every turn, let's people challenge their governors. This idea of second term is certain, like Hausas will say, dole, shouldn't be so. It should be based on performance. So let's the people be able to challenge, status quo, and if it doesn't go well with them, let them vote out such a candidate. So when the court now begin to pander after elections, you pander towards moods, then the court will no longer be determining the law, but just general issues outside their domain. So I don't think they will look at mood, because mood also, another thing is that mood can be determined by the now. Because if you come as a governor and then you start very well, the fact that not everybody accepted you when you contested, and then in 3 months in office, 90 days, you started so well. Yeah. The mood, you can change the mood. You can buy over, with your good work, the people that didn't vote for you before, to say, look, let's give this man a trial. Let's support him. That's because time has changed. Unlike when you contested for office, when you had nothing to point to. So that's why also the court will not look at mood. They will strictly look at the letters of the law. But quickly also, on the issue, because there was an issue that came up it was an argument between lawyers too, whether the failure of the judge to sign, or the judges to read their separate judgment was fatal. The Court of Appeal also decided, and I did a research on that. I discovered that the Supreme Court also had made a pronouncement on such practice, that it is only the Supreme Court that judges are allowed to write separate judgment, and the Court of Appeal. But for a tribunal that is not a constitutional, that is not mentioned in the courts, in the constitution, the judges are not, you can just endorse on the judgment of your fellow judges. So
They're
for tribunals,
not obliged
they're
to
not
write their
obliged to
judgments.
write a separate judgment. And so the tribunal also yesterday endorsed that position. And
The Court of Appeal, you mean?
yes, sorry, the Court of Appeal, also endorsed and allowed that position and said that the fact that the judge, the other judge at the tribunal signed the judgment, is enough. It means that, he agreed with the position of the presiding judge. And
okay, so I want to talk to you about the stance of the the INEC Council. After the ruling yesterday, he did say that the ruling in itself was an renovation, of course, on the Electoral Act with a focus on Section 137, and he referred to it as a beacon guide to the ongoing election tribunals. Do you agree with this stance, or do you think that maybe he might be putting one foot ahead of the other too quickly?
Yeah, I want to please permit me to... You see, INEC in this case is a nominal party in election matter. Like I said before, you find out that once election results are declared, they are presumed regular. And if you permit me to quickly read Section 137 of the Electoral for the benefit of our listeners, it shall not be necessary for a party who alleges non-compliance with the provisions of this Act for the conduct of the election to call oral evidence if original or certified true copies manifestly disclose non-compliance, the non-compliance alleged. But here, what the judges are saying, that because a lot of people had said that if the non-compliance or the irregularities are manifest in the document presented, and so you don't even need to call witnesses, because the presumption is that for electoral matters, for you to disprove any result declared, you must call polling unit by polling unit. So what the Court of Appeal simply did was to say it is not every document. It is not every document that is coming from INEC that you would say, is showing manifestly, or every document coming from INEC can be relied on to prove irregularity.
Whether it's a true reflection of what actually the
that you must still go back. You must still go back to establish what happened, to prove before the tribunal what actually transpired. And so, it is not enough to say because you obtained documents from INEC that there was no need to call witnesses to speak, like we say at the tribunal, to speak to those documents. And that there's need to speak to the documents that you have tendered. So, that this case, it is when results declared, I think what the tribunal's view or the Court of Appeal's view would be, when the results declared from EC8A, so obvious, it is so obvious from the result, from the face of the result, or from the result on the BVAS or IREV, that there were irregularities. That is when you might not need to call witnesses. But what the tribunal had said now is that, look, in this case, you're relying on a secondary document. You can't rely on those secondary documents without still calling witnesses. So the tribunal did not it expanded Section 137 and did not rubber stamp it the way it is couched as some lawyers would want to presume.
Okay, so I mean, I'm taking two key things out of this judgment by the Court of Appeal, and I'm interested in how you think that could be a kind of guide to what to expect at the federal, which you made reference to, given the fact that 4 parties have instituted, petitions, but key among them, of course, will be the Labour Party and the PDP. So 2 key things that, on the beavers and the, proving overvoting and irregularities. One, that voters register is intrinsically part of accreditation process, And that secondly, Section 137, which you have referred to, which you read out from now, of the Electoral Act, only lightens the burden of the petitioner, but does not totally remove the burden.
Fantastic.
Absolutely.
Fantastic, because before, with the introduction of Section 137, the presumption was that you no longer need to call all those witnesses that you need to call. once you tender this document. And that was why the APC were very happy with the report they got from INEC. They went to town,
the back end
and
thing.
the back end report, and that was the song, the entire whole tribunal overvoting, and all of their cross-examination were in line with that overvoting. Even the INEC witnesses, they confronted the INEC witnesses with that document, the report from attached to the exhibit attached to INEC defense, and that of PDP, to prove that these documents, there were discrepancies. So they were relying heavily on section 137 that, once these documents have established, manifest discrepancies, it is enough. We have done our job.
Yeah.
And the Court of Appeal, in its wisdom, said, no, that's not enough. You have not even scratched the surface.
Yeah.
So what you're doing is you're relying on the witness of the defense of the respondent without even taking a step to call witnesses in proof of your own case.
Yeah, the strength of
your own case. So you need to call. You can no longer just jettison.
Yeah.
Because Beavers has said there must be accreditation.
Yeah.
If you're claiming overvoting, you can no longer just completely jettison the electoral register.
Yeah.
It also had to play a key role.
Yes.
You also have to bring accreditation. The Beavers that was specifically used for the accreditation process also must be examined to establish that the people you are alleging voted actually were registered or were accredited to vote. And you must also call the agents at the polling unit that witness these irregularities to also speak to the documents that you have tendered.
I think that was where the Court of Appeal in the judgment mentioned the expertise and the adequacy of the witness that you are bringing.
Yes, so that's why I said what the Court of Appeal has simply done now, because this is the first test case for Beavers.
Yes.
So what this Court of Appeal has done now is to give a window into its mind in the way the law runs. In as far as overvoting or irregularities in election is concerned. And so because I also said these lawyers are part of, some of them are part of the team that would, handle the matter at the Presidential Election Tribunal. So this also will give them opportunity of what to expect and what to do. And lastly on this, it's also very clear now that unlike before, you just go fold your hands and say, well, all I need are the documents. You see them applying for documents. Give us a report from the back-end server and the rest. And at the end of the day, you say, yes, I've gotten the document. I really don't need witness, because APC didn't call, many witnesses in this matter. One would have expected, because for a governorship election matter, sometimes you call as many as 100 witnesses if the time permits you. But when you just call a few witnesses and then you front load documents and you want to speak only to the document, or just believe that the court should, look at the document and then conclude or allege overvoting. Okay, so Court of Appeal now is saying no.
They say no. Okay, so quickly, Liborous.
Yes.
just quick one. I gave an indication earlier. So if the Supreme Court, sustains, retains this judgment, by the Court of Appeal, are we therefore expecting that the suits that the Labour Party on the one hand and the PDP on the other hand, at the federal that they have instituted, the burden of proof will now rest on them, just like APC, in Osun State. To prove irregularities and why,
and also provide witnesses that they need.
And evidence.
So you see, the Labour, if the Supreme Court allows this position, it takes us back to the fact that for overvoting, you must rely on the strength of the evidence of your witnesses. It's the age-old long principle of proving irregularities in election petition. And then also, the Labour Party case is not completely on irregularities because in one breath they had said the processes were irregular. In another breath they said declare us as winner of the process. They're also alleging some salient technical issues of, look, the candidates were not qualified because it is also a ground for filing a petition that in the first place, the candidate that you declared as winner was not qualified in the
ought to have run.
He ought not to have participated in the process, which also was one of the grounds of the APC, challenging the competence or the candidature of Adeleke to run.
Okay.
So all of these would form, another set of angle that the Labour Party petition will be viewed from. They are also alleging whether the case of forfeiture and payment of fine will amount to, criminal indictment or conviction as alleged, as stated by the Constitution. All of these the court will also determine. They've also raised the issue of double nomination. So all of this the court will look at distinct from the irregularities. The issue of irregularities, they did not place heavy reliance on those ones because
unlike PDP.
Unlike PDP, yes, because to prove irregularities across the federation and begin to call witnesses polling unit by polling unit, you will need more than 6 months to do that. So they are looking at the technical side of it and different from what the APC or APC is looking at in Osun. APC is only looking at, the overvoting from the back end, report from the back end server, and then the fact that Adeleke supplied false information. And the court said, well, the Court of Appeal had dealt with that and said the man is qualified. And so the law is what the court says it is. So if a court of coordinate jurisdiction has dealt with that, we would not want to sit on appeal here on a matter that had been handled by a court of coordinate jurisdiction. So to that end, that will rest that case. And then the other issues are issues that, they mainly dwelt on, that are distinct and different from the Labour Party and the PDP presidential, issues at the tribunal. I don't think they will make, so much noise about the issue of irregularities, but they have raised irregularities. But like I said, it is a tall order. So they will dwell on those other issues, technical issues that they have raised. But the challenge with that is that just like the server issue in 2019, is that once it fails, it fails. Once it goes down, it goes down. So you can no longer, then it's the opportunity for people to debate whether the court was right or wrong will no longer be there, because overvoting and irregularities are viewed separately, by parties concerned. So those that witness it will consistently tell you that, look, in this place we saw the irregularities, as distinct from when you are saying there was a server or there's a server and we have information from the server and the owner of the server said, no, there is no server. Or you say the man is not qualified, he's been convicted. And then the court says, no, from the document that we are seeing here, it is not a conviction, but something otherwise. So all of this, will, that's the danger in hinging your, grounds on just, those technical areas. But for me, I think the time has come for us to amend those clauses. Where you presume once, no matter how irregular the electoral processes are, not just INEC now, because the parties also, that is why politicians will tell you, we will do whatever we do to be declared winners. Then you go to tribunal because they know go to court because they know that it is not enough. Also, I want to disabuse the mind of people that says, oh, because they know that they own the judiciary. No, that's not the issue. Because the processes have been presumed regular. So I think we need to reverse that. We need to reverse that presumption of regularity in favor of INEC.
Now, constitutional lawyer and public affairs analyst, Liborous Oshoma, thank you so much for joining us on the Arise Morning Show.